Appreciate the opportunity to give this talk. I gave my first talk in 2014 and argued that genital cutting is intentional fraud by doctors and their trade associations. Then in 2016, I argued that it's a breach of fiduciary duty and constructive fraud. I'll discuss what that is today in this talk. So here's what I intend to show today. The first is that child genital cutting is indefensible, no matter what arguments are put forward in favor of it. Second is that the victims have several different types of legal claims. I'll summarize what those are. Then the most novel part of the talk is the argument that victims of unnecessary child genital cutting have the right to win without a trial, which has important implications. All right. So the public, where female genital cutting and male genital cutting are common, the public may not even be aware that there's a debate. But of course, genital cutting has been debated for thousands of years. As discussed by others, it's been performed as a sacrificial religious ritual, painful rite of passage by Muslims and Jews and in tribes. So they're impliedly, they claim by implication the right to engage in it. On the other hand, the Greeks considered it to be a mutilation, odious, wouldn't let athletes compete in the Olympics in Greece if they were circumcised. And it was a capital crime, punishable by death among the Romans. And so the debate continues into modern times, so that there's religious debate as to whether there's a religious right to cut a child's genitals, especially male genital cutting. There's medical debate. So is it good or bad for health, or some of both? An example would be the issuance by the American Academy of Pediatrics of guidelines in 2012, and then 38 medical experts from Northern European countries, Frisch et al., argued that the US physicians and trade associations, medical associations, were culturally biased and that their opinions was of no value. There's ethical and legal debate. So the CDC argued in its guidelines that it's ethical to circumcise boys because between adolescence and becoming adults, they might engage in sexual intercourse and contract sexually transmitted diseases. On the other hand, Svoboda and others have argued that it's a form of iatrogenic harm, unethical, published in the Journal of Medical Ethics. Then there's legal debate. Stephen debated Dr. Brady at a conference in Charleston, South Carolina, where Dr. Brady argued that male circumcision is legal. All he could point to in support of that proposition was the claim that it had never been prosecuted. So in my view, there has not been any real, genuine ethical and legal debate, but there is some. And then there's policy debate. So Lena News yesterday talked about influence of governments, Israel putting pressure on Denmark and the United States. So regardless of whatever human rights there may be, even if there's a legal right to an intact body, there's still a policy debate. Should we do anything about it? For example, might it go underground? So my next point is that lay people can't resolve these debates. They're not doctors. It's case law saying that patients have no knowledge of the law. Physicians have superior bargaining knowledge and bargaining power. Patients and their legal representatives have no choice but to trust physicians with their health and safety. And doctors in the US and their trade associations and in Africa promote male genital cutting. And so people believe this, believe there's a medical basis for it. They're not lawyers. And as Dr. Brady said, there's no law against it. Nobody's been prosecuted. So it's reasonable to believe that parents have the right to elect it. All right, so can the debate be resolved? How? Well, suggest step one is find out what are the legally relevant facts. They're called material facts in the law. Facts that cannot be genuinely disputed. Of course, any facts can be disputed. Can they be genuinely disputed? And then let us make the assumption that the medical claims are true. So, for example, the claim is that male circumcision reduces HIV during heterosexual sex by 60%. In relative terms, that's 1.3%. In relative terms, Hill and Boyle showed in an article in the Journal of Law and Medicine 2011 that there are so many problems with those studies that they can't be trusted at all. And then there was a recent study in Canada showing that circumcision does not reduce the risk of HIV. Anyway, this debate could go on forever, but let's assume those claims to be true. So then we want to apply the rules. What are the rules of medical ethics and of law? So let's start with the facts then. These are facts common to male and female genital cutting. So they both cut into and irreversibly amputate living tissue from healthy children. So they're not suffering from a medical condition. Only performed if parents elect it. Very importantly, it's non-consensual and not incidentally over the child's objection in most cases. Perhaps in some tribes, boys might welcome a circumcision ceremony, but for the most part, children make very clear they don't want to be circumcised or have their genitals cut. It's indubitable that it's risky to have part of one's body cut off and that it's harmful. So pain is harm, loss of tissue is harm, and a scar is evidence of a wound. And indeed, male genital cutting and most forms of female genital cutting are very harmful, as you know. So for example, male genital cutting removes half of the penile tissue, removes the most sensitive part of the penis, and destroys its mobility and protective function, among others. So what are the rules, the ethical and legal rules? And so Brian Earp and others who've signed on to the Brussels Agreement, Brussels Collaboration, I think it might be called, all agree that male and female genital cutting must be treated the same way from the medical and ethical and legal perspectives, regardless of gender. And indeed, all unnecessary non-consensual cutting, such as other body modifications and unnecessary surgery, must be treated the same way. All right, so then what are the child's rights and what rights are violated? Genital cutting, regardless of gender, violates the right to bodily integrity. So this is a foundational principle in Christianity, Islam, and Judaism. So for example, the Arabic translation of bodily integrity is that the body is sacred and transgressions into the body are forbidden. So it's the right to personal security, the right to an intact body, the absolute right to be left alone, So the United States Supreme Court stated in 1981, Union Pacific Railway versus Botsford, no right is held more sacred or more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. Quote, the right to one's person may be said to be a right of complete immunity, to be left alone. And so this is a fundamental absolute legal principle worldwide in common law countries dating back to Blackstone's commentaries in the mid-1600s. The English-speaking countries are all common law countries. They all adopted the common law of England. This is the law in civil law countries. So, for example, EU law states, quote, everyone has the right to liberty and security of the person. It's part of constitutional law of these countries listed here, and likely others, because many constitutions are based on the US Constitution. It's also an international law violation, and therefore violates the child's rights in every country in the world. Article 3 of the Universal Declaration of Human Rights says everyone has the right to life, liberty, and security of the person. The International Covenant on Civil and Political Rights, Article 3, says the same thing. Everybody has the right, everyone has the right to liberty and security of the person. So any intrusion into the body violates this right, no matter how slight, even a pinprick. And there's a presumption in the law that the touching is unlawful. And this is very important, because what it means is that the person doing the cutting or any medical procedure has the burden of justifying it. It has to rebut the presumption that it's unlawful. So the important implication is that the burden is on parents and physicians to justify genital cutting. The burden is not on the child or the man or woman the child becomes to prove that their rights were violated once they make the claim. Doctors and parents have to rebut the presumption. Now, it's impossible to justify genital cutting on non-medical grounds. The American Academy of Pediatrics claimed in 2012 that parents will need to take into consideration non-medical factors, their aesthetic, cultural, and personal and religious preferences. The benefits are not great enough to recommend circumcision, so more is needed, some more non-medical grounds. So the main reason parents select circumcision in the United States is so that the son's penis will match the father's penis. So this is an absurd argument. Somebody here has a t-shirt where the father is a pirate with a hook in his hand. If this were true, then the parent could choose to have son's arm cut off and wear a hook so they could match. Cultural reasons, also absurd. Slavery was performed for thousands of years. Scarification, anyone, is to quote Georgianne Chapin. So cultural reasons are out. So what about religious reasons? That's the strongest argument of non-medical grounds. So is there a religious right to circumcise boys and girls? And the answer is no. In the United States, the First Amendment gives a right of freedom of religion. Government can't interfere with religious choice, but there's no right to intrude into another person's body. These inalienable rights that all came from the common law of England, they all adhere to individuals, the rights of one's person. They don't extend to intruding into another person's body. Moreover, the child has a right to freedom of religion. And so it violates the child's freedom of religion to mark him, or conceivably, in theory, her, as belonging to a religion that he or she may later renounce. So this case law, this Prince v. Massachusetts case, 1944, that says that a parent cannot harm or even expose the child to the risk of harm for religious reasons. Another proof that there's no freedom of religion to intrude into the body is the child abuse statutes don't contain an exception. They don't say unless you are conscientious religious believer that the cutting is justified. So genital cutting is also impossible to justify on medical grounds. Frisch et al. And British Medical Association have stated the rule physicians must justify every medical procedure, of course on medical grounds, and hence they must ignore parents' personal preferences. Physicians are required to give competent care that patients need, regardless of what anybody else wants. So doctors must have a patient, meaning a person suffering from a medical condition. They must give a diagnosis. They have to recommend the optimal treatment and consider alternatives, including the alternative of doing nothing. Physicians who circumcise don't do that. So the American Medical Associations know that circumcision, now I'm talking about male genital cutting, is not medically indicated. In 1999, the American Medical Association literally said it's not medically justified. They said it cannot be responsibly viewed as protecting against sexually transmitted infections. No National Medical Association, singular, has ever recommended it. As Robert Van House states, healthy children are not suitable candidates for surgery. The rule is do not operate on healthy children. I submit it's impossible to argue with that proposition. So healthy children, they're not patients. They're entitled to be discharged from the hospital. Genital cutting does not meet the definition of surgery. Surgery, I think as Steve said yesterday, is cutting into the body to remedy diseases and injuries. Genital cutting is simply violence. It is literally the opposite of medicine. So what about the argument that male genital cutting reduces the risk of some diseases? So it's unethical to harm the many to help a few. So if the claim were true that you circumcise 100 boys, you prevent one urinary tract infection, that means you harm 99 boys without helping them at all. Whereas a doctor has to provide the optimal treatment for each patient. So there's a rule against unnecessary surgery, legal rule and an ethical rule. Violates the child's right to autonomy, we'll get to in a moment. The Hippocratic Oath, first do no harm. The rule of beneficence, or do good. The rule of proportionality, do more good than harm, do the least amount of harm while doing good. And unfairness, since it's performed without consent, and moreover, men and women rarely choose to have their genitals cut themselves. They do not want to be. So it's unfair to them. As you know, boys are not at risk of adult diseases, so none of these arguments about penile cancer, sexually transmitted diseases are of any merit. They're irrelevant. And moreover, there are better harmless ways to prevent all of these diseases, so there's no medical advantage to male genital cutting, meaning there's never a valid medical reason to do it. So regardless, genital cutting violates the child's right to autonomy, self-determination, freedom, also referred to as the right to privacy in matters involving sexuality. So freedom is a fundamental philosophic principle dating back to Bentham, Locke, and Mill, and a foundation American principle, of course. So it's a corollary. If one has a right to an intact body, one has a right to determine what is done to it. Children, by law, have the same rights as adults, and so their rights are held in trust, according to Joel Feinberg in 1980. The right to an open future. And therefore, physicians and parents must defer genital cutting until adulthood. All right, so what legal claims do victims have? Under the criminal law, it's criminal assault and battery, defined as, well, I'll let you read it. Importantly, it says no matter how slight, without justification or excuse. So an example is the Cologne, Germany case in 2012, where the court boldly held that there's no right to circumcise a boy for religious reasons. It violates the child's right to bodily integrity and self-determination, and the child's rights supersede the parent's rights. It's child abuse, means any physical injury inflicted on another person by other than accidental means. Great article by Brigman on that in 1985. It meets the definition of sexual assault, but has not been prosecuted, as you all know. All right, so what legal claims do victims have? I could call on Andy Little here. He did a great job yesterday summarizing them. So one is a battery, the same definition as under the criminal law, an intentional touching, no matter how slight, even a pinprick, therefore, that is harmful or offensive and not justified. So then physicians have a fiduciary duty to their patients. The entire relationship is based on trust, based on this unequal bargaining power. So of course, physicians have a duty to respect the child's rights that we just talked about. They have a duty to justify every operation on medical grounds, which we just showed can never be done. They have a duty to act in each child's best interests. And they're certainly not allowed to enrich themselves at the expense of their patient. So then, as you know, as you may know, I wrote a book, Circumcision is a Fraud. I invite you to read it and hopefully leave a rating would be appreciated. Arguing that circumcision is intentional fraud. The definition is intentional deceit that deprives a person of something of value or of a legal right. So genital cutting does deprive a child of something of value and of a legal right, as we just showed. So I don't want to take much time on each of these, but the fraud permeates the industry. It starts with fraudulent marketing, such as saying it's good for health and a parent's right. Then there's fraudulent conduct in the hospital, targeting boys unable to object, mothers who have just given birth and are legally incapacitated, badgering parents, on average soliciting their consent 8 times until they relent. Fraudulent medical claims that it's good for health and not bad for health. Fraudulent diagnoses, especially phimosis or a tight foreskin, which as discussed yesterday is normal. Fraudulent legal claims that doctors have a right to perform the operation at all and that they have the right to offer to parents and to take orders from parents to operate on perfectly healthy children. Fraudulent consent forms that a paper is underway on that. I believe there's a talk about it today. And then fraudulent Medicaid claims. So doctors fraudulently certify on the Medicaid form that it was medically necessary to circumcise newborn boys, which it never is. And they use false diagnoses like newborn boy and phimosis. And states let them get away with it, some states. So then what's this constructive fraud that you've been hearing about? So once a patient claims that a procedure is a breach of fiduciary duty or trust, a doctor has a burden of justifying it. And if the doctor can't, then courts impute or presume fraud to have occurred. So it's a legal fiction, but it's needed to prevent unfairness. Otherwise, the doctor would just say, well, I didn't know. I didn't know it was bad for health. Very importantly, the statute of limitations for fraud claims begins upon discovery of the fraud. So most people have no idea they've been defrauded. So the parents are defrauded, but the parents are standing in for the child. So the child is also defrauded, even if the child cannot reason yet. And therefore, most victims have viable constructive fraud claims and the right to bring those claims even if they're 50 years old in theory. So I have only one slide about the right to judgment without a trial. So it's called summary judgment. Courts grant summary judgment when, quote, there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. So what I've argued today is that general cutting is indefensible. There are no material facts in dispute, and there's a legal right to prevail. So, for example, Congress recognizes this in the context of female genital cutting. It's actually 1997, I think, passed the anti-female genital mutilation law. And it said, in effect, female genital cutting is indefensible. It's practiced for religious and cultural reasons. It's harmful. It violates federal and state statutory and constitutional rights. And it also violates the child's common law rights. And so I had the insight, the reason I thought, is there a right to summary judgment, is when I realized that in the German case, there was no trial. The court decided on the facts that there was no right to circumcise for religious reasons. And there are a lot of European cases that Attorneys for the Rights of the Child has translated and compiled. And in most of them, the ruling is that a parent does not have a right to circumcise a child for religious reasons. They often block one parent from circumcising a boy for religious reasons. And they do that without a trial. I think this is very important. It's very promising. What it means is that boys and girls can sue and have a right to prevail without a trial. So a court, Tortorella versus Castro, said, it seems self-evident that its unnecessary surgery is injurious and causes harm to the patient. And the law is clear, it violates the child's right to bodily integrity and self-determination. And therefore I contend genital cutting is indefensible and the circumcision debate is over. That doesn't mean it won't be debated. Probably be debated for the next 1,000 years. But what I'm saying is there's no real debate. Another important implication is that there's no need for malpractice suits. The malpractice suit is expensive. You need medical experts. You have to get through, sometimes through some obstacles in order even to get to court. So what I'm saying is if it's indefensible and you have a right to sue for these other, for the harm, you don't need to prove that the operation was performed negligently or badly. All you need to prove is it was performed and should not have been performed at all. So there's a right to summary judgment on all the counts except the intentional fraud claim. In intentional fraud, you need to prove intent to defraud. However, that can be proven by circumstantial evidence. And the circumstantial evidence is very strong that the AAP issued intentionally fraudulent guidelines in 2012. And moreover, there's a rule that when a person acts recklessly with reckless disregard for health and safety, then they can be held liable for intentional fraud as if they intended to cause the harm. So my final slide is that justice has been elusive in the USA. It's cultural bias on the part of judges against it that others have talked about. So in the San Francisco, citizens had a legal right to put circumcision on the ballot, and legislation was passed taking that right away and saying that circumcision has an array of medical benefits. In the Hieronymus case, a physician testified that circumcision is risky, and the judge said it's very, very safe. It's untrue. Risks more than 50 complications. Jailed the mother until she gave permission. That was coercion, legally invalid. Of course, she had the right to withhold her permission. In the Clapper case, Harvard approved every word in his play. Harvard has a policy encouraging free speech, promising not to retaliate, but they didn't like his message, and they fired him. Then he brought suit. The case was dismissed in one day. I was informed that the judge plays golf in the same country club as the defendant's attorney who went to Harvard. Dismissing a case in one day with prejudice, without right to amend, suggests out to get him, not justice. And it violated a federal rule. So he has a right to prevail and a right to amend. It's on appeal. The Medicaid case, we had a Jewish judge below in Massachusetts and we prevailed. It was a wonderful victory. We were arguing the state's not allowed to pay for unnecessary general cutting. It violates federal and state Medicaid law. But an appeals court reversed it. And I went to the oral argument while I was arguing with my co-counsel, Andrew Delaney, who's a wonderful lawyer, great orator. And when we arrived, the judges two of them were like this. And they just seemed completely skeptical that taxpayers should have the right to challenge circumcision. They considered it to be a medical procedure. We couldn't change their minds in 15 minutes. We got a ruling that we think is wrong, and we're appealing it to the Supreme Judicial Court. I was thinking, well, that's wonderful. It's a liberal court. And David Llewellyn tells me that the chief judge slammed him in a circumcision case. So it's very difficult to win circumcision cases in the United States. So I suggest this big reward possible, but a risk of unjust results until public sentiment changes. And it's been said laws change more slowly than custom. Therefore, very important to encourage young people to join the movement, oppose circumcision, so public opinion changes, and then the law will follow. And of course, there's also a need for new litigators and trained litigators and medical experts and funding. But I'm encouraged by the formation of GALDEF, a genital autonomy legal defense fund that I think will assist with the funding. I think I've definitely used up my time. Thank you very much.